Good afternoon, everyone. My name is Anmol. I work as a legal associate for Land Conflict Watch. For our third and final presentation, I will try to keep it brief so that we can get to the panel and we can discuss commons a little bit more at length. But before we begin, I would first like to introduce what are commons, because many of us already know what are commons, but for the benefit of everyone else. Common property resources refer to non-exclusive areas. So the key feature of these areas is that no one person has formal rights over such areas. So in the case of private property, you have private persons who have rights over such lands or such resources. But in commons, it is characterized by many people, a group of people or community of people having rights over such land. So for instance, if you have a park which a community has access to, and this park has fruit bearing trees, by the principles of commons, ideally the people in that community should be able to harvest the fruit of those trees and use whatever resources are present in the park. What we hope to understand through our research today is disputes and conflicts that happen over common lands. Now, commons can mean anything. They can mean digital commons, they can mean common lands, they can mean water commons. But again, like, our emphasis today is on common lands. As most of you who have been here for the previous presentations would already know, we classify conflicts in our database by tenure type, meaning that we do classify conflicts by common, private land, and instances where both types are present. But what we further do to understand the nature of disputes over commons is that we also classify by type of common land. So the major category for us in the LCW database is forested commons and non-forested commons. Now, Mrinali has briefly taken you through it, but what we keep finding through our research when we look deeper into this one specific issue is that there is a very interesting dichotomy which emerges between forested commons and non-forested commons, which is that when we look at the legal processes, it becomes a little evident that first, when we look at forested commons, it's very clear that the biggest issue that emerges is a non-implementation and violation of FRA. And even the lack of legal protection of land rights relates to formal land rights that the community may have because of FRA. But we don't see that same kind of consensus in non-forested commons. I'm not sure whether it's visible from the second graph, but we can see that the most frequently occurring legal issue in non-forested commons is forced evictions or dispossession of land. And you can see that it's only 36% as opposed to non-implementation of FRA, which is 72%, and that's more, which gives a very clearer consensus. What we further found out that when we look at the legislation which is applicable, we get more nuance into this issue. Of course, because non-implementation of FRA is the biggest issue, which is the most commonly occurring issue that happens in forested commons, the FRA is also the most commonly applicable legislation that is to follow. But what we find with non-forested commons is that you don't really have legislation that have that kind of consensus all across conflicts in non-forested commons. That means that the nature of these conflicts are going to be very varied. And we wanted to understand why. And another data point that we look at first, that we need to look at, is that the kind of conflicts that we are looking at in forested and non-forested commons also have different rates of litigation. So you have this very strange phenomenon of forested commons being very clear to understand, because yes, it is regarding the access and use of the forest itself by these forest dwelling tribes. But for non-forested commons, we don't have that clearer picture, but you get scattered inferences that you can maybe draw that forced evictions is a recurring issue, but no clear consensus on which legislation would be applicable in this. So we wanted to understand this a little bit more, and what we went to understand this a little bit more is that when these communities in non-forested commons actually go to court, which law is actually being applied, which law is being applicable. And we came to this one particular judgment which was passed by the Supreme Court in 2011, which ties all of these elements together, and that is Jagpal Singh versus State of Punjab. Now, Factually, this was a dispute concerning encroachment on a common water body. It was a pond. The encroacher went and appealed all the way to the Supreme Court. The facts in the case itself are not that important as is the legal pronouncement which followed, because the judgment came down so critically on these encroachers, and it was one of the first few judgments which actually really emphasized the need to protect commons. So what we see is that there were these very all-encompassing directions which were passed for the entire country. Directions were passed to all the state governments that they had to protect and restore commons. That was first and foremost. And how do they do this? It is by preparing schemes. The state governments were directed to prepare some schemes, and these schemes would be for the eviction of encroachers from these common lands. And in Jagpal Singh, at least, we are concerned with Gram Panchayat land or village land. So in Jagpal Singh, we see wording which is specific to village land. It mentions Gram Panchayat land, it mentions Shamla De land, which is another form of village land. But what is special in Jagpal Singh is that there's this observation which comes through, which said that all these encroachments are often carried out using muscle power and money power, and it is done in collusion with the officials. Now, this kind of observation attributes a sort of motive to these encroachments, and it's probably not new, but it is new in terms of the threat to commons. And it's probably the first time that the Supreme Court has come and weighed down so heavily on the need to protect commons, and this is the problem that commons need protecting from. Jagpal Singh does create an exception as well. It says that certain encroachments can be permitted, which is when land has been already leased to people from landless communities or from scheduled castes or scheduled tribes. And they also create another exception, which is that when the land is being used for some public utility, so for instance for a hospital or a school, then such encroachment should be permitted. For this report itself, we undertook a very comprehensive legal research where we first looked at 110 filings submitted by the state government in the original case of Jagpal Singh. Now, in this original case, state governments were directed to keep filing compliance reports as well. This stopped after a while, but we have a record of at least 110 filings that were filed. So it is important to look at what the states were saying, that what measures they were taking to actually curb this problem. And then we looked at state legislations which kept reoccurring in these affidavits, as well as in our High Court analysis as well. The main chunk of this report is dedicated to an analysis of over 300 High Court judgments, which were passed until November 2021. That's when we started our project. These High Court judgments cite Jagpal Singh. So they may either refer to it, they mention it, or they may reject it as well. And we also looked at land conflicts over common land from the LCW database to understand this problem a little bit more fully. This is just to give you a glimpse of the kind of methodology we followed. So with legal research, a problem is that you have a lot of subjective information, or you have a lot of information that you need to distill down. So what we do is that we try to record all the necessary details, and then we distill it down to one or two specific parameters. And it's more evident even with our High Court analysis, where, of course, if you've ever read judgments of these kinds, they are often like paragraphs and paragraphs of judges of certain things being said about encroachment. But at the same time, we need to separate that from what directions are actually passed and what actually happens to the affected communities. Because the two things that we want to keep asking throughout this report and through our research is, how does this affect commons, and how does this affect the communities that are dependent on commons? So if I won't delve too deep into it, but if you can see, the second row are boiled down to yes or no parameters, and the top row are more subjective fact finding factors that we wanted to record. And one thing that I do want to mention is that in our research we do clearly note down when certain details are not mentioned, because that is also important to record. Because if it skews the data, this is something that I will also come to later. This is something necessary to record because it also uh, raises the question of what kind of facts are actually being said in these judgments. So I would like to briefly take you through the key findings of our report. So for that, firstly, I would like to take you through what we found from the High Court cases itself. Now, one very concerning thing that we found in in the Jagpal Singh cases is that even though we have created this classification of trying to understand the nature of commons, largely the lands are classified as government lands. It is very distinctly noted as these lands belong to the government. They are utilized for this purpose, or they may be a water body, or they may be village land, they may be wastelands, but it is always traced back to the ownership of the government. But even when the nature of the land is not mentioned, there is an explicit mention that such lands cannot be encroached upon because they are government lands. And in those cases, we have also tried to note down in how many of these cases government land is sought to be protected, because there's no question of commons when it's plainly and simply called government land. And in as you can see from the graph, government lands end up being 7% of our entire data set. Of course, the largest data set is water bodies, because Jagpal Singh was used for a case regarding a water body. So high courts also applied it to similar facts that were before it. We also found that there is a very conspicuous absence on judicial reasoning on the need to preserve common lands. So what do I mean by this is that we see that this lack of discussion on essential details like such as nature of encroachment and nature of commons leads to very summary judgments, very brief judgments which say that so and so person must be evicted. Simply, it just said there is just a recording of the land in question and the person's name, the encroacher's name, and it just goes ahead and says that such people must be evicted. Now, this is not helpful for us, because if we are trying to gauge what economic bracket these encroachers are from, it's not immediately clear to us. And even then, when we see the judgments in themselves, we see that the directions passed clearly emphasize directions for eviction rather than restoration of encroached commons. Here we try to record the explicit directions passed in both of these cases, and we did find a much higher rate for directions passed for eviction as opposed to restoration of commons. So there's very little discussion of should this land be returned to the village, should this water body be restored to its former state. Such discussions are very conspicuously absent. Sorry. Next, what we found is that because the majority of these cases did not mention the nature of encroachment, the largest category of our classification of cases on the basis of encroachment is not mentioned. Now, again, this may as well, thank you so much. This may as well mean that we have a large vacuum in our data because the courts have failed to mention these details. But within the cases that we have which do mention these details, we see that housing is the largest category. Now, housing here refers to the category of people which do not have formal rights over their housing. So this does not mean private property. This does not mean that when we own private property and we encroach upon land, that is for the category of private property. But this means that people who stay in bastis, people who stay in slums, all such informal housing structures. And this is particularly egregious because of course, like, the right to housing is something which is considered a constitutional right. It's an extension of Article 21 as recognized by the Supreme Court before, and it is something that is very rarely discussed when it comes to encroachers. And finally, our most important finding from the High Court cases is that there is an exception which Jagpal Singh creates for landless people, for people from scheduled castes and scheduled tribes. And what we found is that first, most of these judgments do not note whether or not the encroacher is from these protected groups. From the 28 explicit cases that we noted where these protected groups were involved, we found that 15 cases ended up in directions for eviction. Only one of those cases ended up in regularization of the encroachment. It's also this also leads us to the larger question of how Jagpal Singh's exception has been categorized, how it has been applied, because Jagpal Singh's exception creates two categories in itself. First is on the basis of identity. The second is based on the use of the land. So for identity, you have these protected groups. So based on your identity of belonging to scheduled castes or scheduled tribes, and for based on land use, you have the exception for public utility. What we try to trace throughout our report is where maybe the exception for identity has been rejected, the exception has not been applied properly, and where for exception for public utility has been applied. And some of the more egregious cases from these findings include Gujarat High Court regularizing a power company, power corporation setting up their power plant on grazing lands, even though grazing lands is something which is very zealously protected by high courts in the other judgments, and it is done in the name of development, it is done in the name of public purpose. That is the legal reasoning which is used. Next, we would just like to briefly show you what we found from the affidavits that we looked at. We found that largely in these Supreme Court cases, when you see the compliance reports, they tend to reiterate what measures they have taken. But what we found is that only 7 states said that they would, 7 states / union territories said that they would be framing new schemes in light of Jagpal Singh. 23 of these states said that they already have measures in place and those are the measures that they're going to be using. And 6 states said that they are not, Jagpal Singh is just not applicable to them. And one thing that I would like to point out in this case is that the existing legislation that was reiterated included legislation such as the Rajasthan Land Revenue Act as well as the Bihar Land Encroachment Act. And these legislation essentially also conflate government land with common land. So these legislation deal with government land in themselves, not common land. So what we see is that not only is the judiciary conflating this, even the legislation, even the government through its legislative arm is perhaps conflating this distinction between common land and government land. So the emphasis is always on protecting government land rather than common land. And this is, like I mentioned earlier, from the LCW database, what we found is also, this is a combination of all commons. So this includes forested commons as well. The most frequent demand is always demand to retain or protect access to community land and resources and the legal recognition for land rights. And for legal loopholes, what we found is that lack of legal protection of land rights is very often present. And even though this includes forested commons, the issue of forced evictions is something that is seen in both sets of data. Lastly, I have presented a lot of data to you. What I wanted to end this presentation on is a discussion on the heart of our research, which is the affected communities. I wanted to introduce two landmark cases that we have found through this research, and we've also mentioned in our report at length. These are the two cases, T.K. Shanmugam versus State of Tamil Nadu and Chettinad Cement Corporation versus State of Tamil Nadu. Now, both of these are from Madras High Court. Madras High Court has an extensive range of cases dealing with this issue. But these two cases are landmark cases which have been cited again and again, in future cases. Now, why I wanted to introduce these two cases is to introduce some food for thought. In T.K. Shanmugam, this is a case involving encroachment by a colony of people, around thousands of people are involved, on a lake in Chennai, Tamil Nadu. And this community largely is daily wage earners. In most of these cases, people had ration cards, they had all their identity proofs with this as their registered address. In some cases, they also said that they had purchased the land through a registered sale deed. Now, T.K. Shanmugam is basically a landmark case because it expands on a legal principle called the public trust doctrine. And the public trust doctrine essentially says that natural resources or some resources must be maintained for the benefit of the public because the state holds them as a public trust for the people. However, in this lengthy judgment, you don't find the actual fate of the encroachers themselves. What you find is that this case is bounced around, is referred from bench to bench, and the final bench which rendered the final judgment, which actually deals with the encroachers, basically just said that the encroachers must be evicted, and they also blamed these encroachers for causing flooding in Chennai, which has been an issue in the past decade quite a bit, saying that en masse, like all of these unauthorized colonies which have encroached upon water bodies ought to be evicted and water bodies ought to be preserved for the general public. Now, it's worth asking whether these colonies also comprise the general public. That is something that I would look forward to discussing with the panel. And in the second case is the diametric opposite of this first case, which is Chettinad Cement Corporation. This involves a cement corporation basically laying down its own railway tracks on government land, and in the process they damage a water body. What happens is that the Madras High Court comes on very heavily on the cement corporation. They say very explicitly that encroachment is a social evil. This judgment has been cited many times in many other cases. But what happens outside the judgment is something that we don't really see when we only read judgments. What we find is that the cement corporation goes back and they appealed before the Madras High Court against this judgment. They failed. They went and appealed against the same thing in the Supreme Court. They failed. Meanwhile, years have passed. The communities are getting unhappy because the government has not removed the encroachment. And ultimately, the communities file a contempt petition against the government officials for colluding with the cement corporation and wanting them to remove the encroachment. Now, again, the Madras High Court passes a phenomenal judgment which is very critical of the entire situation. But when this time this gets appealed, again in Madras High Court, it does not work. The appeal fails. But when it goes to the Supreme Court for the final time, right now the case is still pending before the Supreme Court, but there's an interim order which has stayed the original judgment. So it's worth asking that if we are looking at encroachers, then which encroachers have the resources to keep using the legal process to get some relief, and who can keep going back. Of course, I'm not going to take more time, but one thing that I just wanted to leave on is that Jagpal Singh has many directions that we can compare compliance against, but most importantly, it frames a problem for us that there is a threat to commons. The threat is encroachment. But if we were to accept this framing for what it is, then we also have to ask, is it eviction of all encroachers, or is it eviction of some encroachers and some not? Do these encroachers have rights? More importantly, who are these encroachers and why have they encroached upon these lands? This is the focus of our next phase of our research. And we are also trying to understand the conflation between government and common land that is being done by the judiciary and the government. Because when we go back to the problem which is also being framed by Jagpal Singh, we have to ask, is this being done for the benefit of commons to begin with? Thank you.
Thank you.